I have a question about the policy, page 12. Actually, about two different provisions. The first one is Part 6, Section A. Permits may not be denied on the basis of the content of the speech, the event, or the exhibit.
Right.
Is there any kind of obscenity exception? I mean, if you know, in general, if there is for public events or public displays, there's usually an obscenity objection. If someone shows, like, trying to show hardcore pornography in public, you know, that's usually considered not covered by the First Amendment. This doesn't. It says permits may not be denied on the basis of content. It doesn't seem like there's any kind of obscenity exception. So could someone show? I mean, something that would be considered obscene?
I think within, and I'm not sure if there's another statute that may cover what you can show in public. Our intent is to be content neutral. And there will be speech that I think one or all of us might find offensive. And that can happen. But I think that's part of what we're looking to do here. And if somebody is seeking to get a permit to do that, that's the time where we can have that discussion. And that's the whole purpose of having this permitting process, so that we can have that conversation with people and we can resolve any issues that come up. If we don't have the conversation, if we don't look what people are seeking to do, in what particular form, in what way, we can't do that.
Okay, well, my second question was about the very next provision of this. Section B, permits shall be granted for public events or exhibits without discrimination on the basis of age, race, creed, color, handicap, there should be a comma there, I imagine. Color, handicap's not a thing. Marital status, sex, national origin, ancestry, and arrest or conviction record. This seems to be, that's where I was. It seems to be lifted pretty much directly out of our discrimination law in general. However, our discrimination law for other kinds of discrimination includes a provision for sexual orientation. And I was just wondering if, under this policy, well, first of all, was it your intention to delete sexual orientation, or is it an oversight? Would the broader discrimination statute still cover it, even if it's, regardless of what this says here?
Okay. Well, we're looking to truly be content neutral. That particular provision is directly out of the Administrative Code, Chapter 2. That's what's included in there that the legislature has passed. We may choose to update that. When we're looking at content, there may be other categories that come over time that we all decide that should be another category. We think by being neutral on content, we will cover all of that. There was no intentional decision to do that. It was taking strictly what was said in the administrative.
Okay, so you wouldn't have any problem with making it match the statutes in general, so that this would be clear that it would match state law that permits shall be granted for public events or exhibits without discrimination on the basis of sexual orientation. I'd
have to confer with our legal team just to ensure that, because we're relying on having to, we want to be able to do that.
This, I mean, I don't imagine that the broader anti-discrimination statute would, I mean, whenever the admin code was developed, I'm sure the broader statewide, laws would supersede admin code. You can't just change the code so that it's more restrictive than the law in general.
We talked about was an admin code too, and again, our full intent was to be content.
So it was just a problem with the administrative code that left this out?
That's where we took it from.
Does the code predate the anti-discrimination law?
The code is, I don't know exactly, but it's back in
the law was in the early 80s, and I don't know where the admin code that really.
I know that's what was in the administrative code, and that's where we took it from.
So can you just say the department's intent is that permits would be granted without discrimination on the basis of sexual orientation?
Until we actually have it in here, I don't want to make that statement, but I do want to make the statement that it looks to be content neutral. If those kind of things, if we can do that and look at what's already in the administrative code, if there's another way to be able to address those issues, we will.
Great question.
I'm sorry.
Just one question. Did you bring an attorney with you today?
I did not.
Why not?
As I said, we
Why
thought
not?
that's inappropriate. This is not the venue for a legal argument.
What is the venue?
It's in the courts. It's in the courts.
Can I ask a clarifying question on that, please, sir?
We have a follow-up question.
Clarifying question. In here, it says that as of December 1st, anybody entering the Capitol building does not have a right to, actually, we have to sever you guys jointly and severally from any liability, from any lawsuits entering this building. So we can't actually take anything to the court for anything that happens at this building. You've made that policy as of December 1st. By coming into the Capitol, everyone has given up consent to have any representation for anything that may happen to them by any employee in here. To my knowledge, the only other place that happens is embassies. So are you telling me that Chief Tubbs is now an embassy staff and that this building is now an embassy and that everyone here is immune?
This covers public events.
This covers public events and public use of this building.
It covers public events.
The way it's worded. You're lying.
Is this, you keep saying that this code is pretty much the same as Administrative Code Chapter 2, which I completely disagree with, but does that mean this is a part of Administrative Code Chapter 2?
No.
Okay, are you sure? Because I'm currently, there's several of us, I think I'm the only one in the room, that are currently under terms of bond for another ticket that we received for protesting and expressing our First Amendment rights. And part of the terms of our bond is that we have to follow specifically Administrative Code Chapter 2. So I'm just wondering if I were to, not follow some of the rules in this old policy, but they're not actually written in the Administrative Code Chapter 2, will I still be bail jumping?
I'm not going to give you a legal opinion on that. I think that's something you have to see.
But
if you're going to have somebody that's going to represent you, they need to represent you as being your client.
what?
That you are their client.
Compliance.
So how would I go about figuring out if that, like, how would I go about getting an answer to that question then, I guess? So it is not considered Administrative Code Chapter 2. So
the policy is, we consider that as part of the statute under Administrative 2. This is the implementation of that. So my belief, again, I'm not a lawyer, and I would suggest that you consult with one if you're looking to do something outside the policy, that this has the force of the Administrative Code.
Wait. But when I first asked the question, you said that it wasn't Administrative Code Chapter 2.
I said you asked me specifically if this.
I said, is this like Administrative Code Chapter 2? Will this be considered part of Administrative Code Chapter 2? You said no.
It's our implementation of the Administrative Code.
Yes, sir. Okay, first, where in there does it say that is part of Administrative Code Chapter 2? I've been waiting a while, so I'd like a couple of questions answered, but I didn't see that when I read through.
The Administrative Code, I'm sorry.
It is part of Administrative Code Chapter 2.
The Administrative Code Chapter 2 gives the responsibility and authority to the Department of Administration for the management of state facilities.
Okay.
And there's more detail to it than that, but that's the basis.
The questions I wanted to ask is, expounding on what other people asked, okay? Regardless, and it's, we won't talk the legal issue, but regardless of whether you have a legal basis for doing what it is, in my opinion at least, what you're doing is circumventing the spirit of the First Amendment, trying to suppress the right of the people to gather and voice their opinions freely. Do you think it is correct that, well, first I would ask, do you think that the First Amendment and our civil liberties are important, and why, when there has been no safety problem, we've had 100,000 people circulating the Capitol, we've had people who occupied the Capitol and were peaceful. The only time that there was any threat of violence was raised by the governor's staff, talking about with the Buffalo Beast, where it was considered, and the chief of police asked about that, where it was considered putting instigators into the crowds. That is the only time that the threat of violence has ever been raised. If it is a public safety concern, I think it is the concern that Governor Walker's staff should be monitored in how it's handled. There's been one instance reported in any situation where any of the protesters that were here to protest Act 10, tort reform, any of the issues that have been going on, have caused a violent scene, failed to, accommodate what was, necessary. We did occupy the thing, but we were completely peaceful. Thousands of people circulating the Capitol, completely peaceful. The only time it was ever an issue of violence or public safety, it was raised by the governor's staff.
The governor himself has committed a crime against the nation. Why isn't he held accountable?
First off, sir, I respect your opinion. Now, as far as, but I feel that from the Department of Administration, we have a job to do. And we believe that we have a responsibility and getting the authority to manage the facilities. And managing the facilities requires having permits and having a way to ensure that we have a safe and secure environment for everybody to express their First Amendment rights.
The other thing I'd like to ask is, in the administrative code that you put forward, it says that there is special instances where spontaneous gatherings are not subject to the same level of suppression.
They don't require a permit.
Okay. What was said earlier, it sounded like that the Capitol Police would disperse any kind of gatherings that occurred spontaneously. Is that true?
No. If you're having a planned event, and the definition of a spontaneous event versus a planned event is in the policy, that, yes, they could. Now, if the other provision, the spontaneous event that is a reaction to another event that took place, and wasn't pre-advertised, and the other provisions that are in there, there is a difference between them. Now, there's still safety concerns within that.
In a situation like this, where if we were concerned about what's said today, we all went upstairs and decided to, individually just make our voices heard, would that be considered a spontaneous event?
Reaction to a newsworthy event, and wasn't. I think this one was already pre-advertised.
So it wasn't pre-advertised by us; it was pre-advertised by you.
You're a shameless.
There are rules and there are rules.
Shameless liar.
So would that be considered a spontaneous event?
These lies.
Yeah, I think in the end it would be.
Thought you weren't going to do legal stuff.
In the end, that'd have to be the interpretation of the police that were here at the time.
So again, there's no. It's all discretionary on the part of the Capitol Police. And the Capitol Police take their direction from the governor's office. Is that correct, sir?
No, the Capitol Police, we have the law enforcement authorities with them. I don't instruct them what to do. Now, the policy itself that we have before us here, we would expect them to enforce in the way that they see most appropriate to protect public safety. Yes, ma'am.